Slide 11. Year 4, Semester 2, Capstone and Specialization. Course, Law. 408, Public Policy and Law. Foundations of Public Policy and Law, Conceptual Frameworks and Institutional Interactions. 1.1 Defining Public Policy, Goals, Processes, and Legal Instruments. Public policy represents the deliberate choices made by governments to address societal problems, allocate resources, and pursue collective goals. Understanding the relationship between policy and law requires examining how policy objectives are translated into legal instruments, how legal constraints shape policy design, and how implementation bridges the gap between aspiration and reality. Policy goals. Public policy seeks to achieve outcomes such as economic growth, social equity, environmental protection, public safety, and national security. These goals often compete, requiring trade-offs and prioritization. Policy processes. The policy cycle includes agenda setting, formulation, adoption, implementation, evaluation, and revision. Each stage involves distinct actors, institutions, and legal requirements. Legal instruments. Policies are operationalized through statutes, regulations, executive orders, judicial decisions, and administrative guidance. The choice of instrument affects enforceability, flexibility, and legitimacy. Real-life example, the Affordable Care Act, ACA, illustrates the complex interplay between policy and law. Policy goals, expanding health coverage, controlling costs, were translated into a complex statute with multiple legal mechanisms, individual mandate, insurance exchanges, Medicaid expansion. Legal challenges, NFIB v. Sebelius, shaped implementation, demonstrating how courts influence policy outcomes. Practical application. Lawyers advising on policy must understand both substantive goals and procedural requirements. They draft legislation, comment on proposed regulations, and litigate to enforce or challenge policy implementations. Students practice analyzing policy documents to identify legal hooks and constraints. They learn to navigate the legislative and regulatory processes. 1.2 Institutional architecture, legislatures, agencies, courts, and stakeholders. Public policy is made and implemented through a network of institutions, each with distinct roles and legal authorities. Legislatures enact statutes, appropriate funds, and oversee executive agencies. Legislative process involves committee review, floor debate, and bicameral reconciliation. Executive agencies implement statutes through rulemaking, adjudication, and enforcement. Agencies possess expertise but must operate within statutory and constitutional bounds. Courts interpret laws, review agency action, and resolve disputes. Judicial review ensures policy compliance with legal norms but respects institutional competence. Stakeholders, interest groups, experts, and the public influence policy through lobbying, comment, litigation, and advocacy. Real-life example, environmental policy involves Congress enacting statutes, Clean Air Act, EPA issuing regulations, emission standards, courts reviewing challenges, Chevron v. NRDC, and stakeholders, industry, NGOs, participating throughout. This multi-institutional process shapes policy outcomes. Practical application. Lawyers represent clients before legislatures, agencies, and courts. They draft comments on proposed rules, testify at hearings, and litigate to enforce or challenge policy. Students practice navigating institutional processes. They learn to tailor advocacy strategies to different forums. 1.3 Theoretical perspectives, rationalism, incrementalism, and advocacy coalition frameworks. Scholarly frameworks help explain how policy is made and how law influences outcomes. Rational comprehensive model. Policy should be based on systematic analysis of problems, alternatives, and consequences. Emphasizes evidence-based decision-making. Incrementalism. Policy evolves through small adjustments to existing arrangements. Emphasizes political feasibility and learning from experience. Advocacy coalition framework. Policy change results from competition among coalitions of actors sharing beliefs. Emphasizes the role of ideas, learning, and external shocks. Real-life example, climate policy illustrates these perspectives, rational analysis supports carbon pricing, incrementalism explains gradual regulatory expansions, advocacy coalitions, environmentalists versus industry, shape policy debates. Understanding these frameworks helps lawyers anticipate policy trajectories. Practical application, lawyers use theoretical insights to design advocacy strategies. Students practice applying frameworks to contemporary policy issues. They learn to diagnose policy dynamics and identify leverage points. 2. Policy formulation and legislative process, drafting, negotiation, and enactment. 2.1 Legislative drafting, precision, flexibility, and political feasibility. Effective legislation balances legal precision with political practicality. Drafting requires clear language, enforceable standards, and accommodation of diverse interests. Precision, statutes must define key terms, specify obligations, and establish enforcement mechanisms. Ambiguity invites litigation and undermines implementation. Flexibility, overly rigid statutes may become obsolete, delegation to agencies allows adaptation. However, excessive delegation raises non-delegation concerns. Political feasibility, legislation must garner sufficient support to pass. This requires compromise, logrolling, and strategic sequencing. Real-life example, the Americans with Disabilities Act, ADA, combined precise definitions, disability, reasonable accommodation, with flexible standards, undue hardship, enabling both enforcement and adaptation. Its passage required coalition building across disability groups, businesses, and legislators. Practical application, lawyers draft legislation, negotiate amendments, and advise on political strategy. Students practice drafting statutory provisions and analyzing trade-offs. They learn to balance legal rigor with political reality. 2.2 Regulatory rulemaking, notice, comment, and judicial review. Agencies implement statutes through rulemaking, governed by the Administrative Procedure Act, APA, and agency-specific procedures. Notice and comment, agencies publish proposed rules, receive public comments, and issue final rules with responses to significant comments. Substantive standards, rules must be authorized by statute, not arbitrary or capricious, and supported by evidence. Judicial review, courts review rules for procedural compliance, statutory authority, and rationality, Chevron deference, Skidmore respect. Real-life example, EPA's Clean Power Plan rulemaking involved extensive notice and comment, scientific analysis, and legal justification. Subsequent litigation, West Virginia v. EPA, addressed statutory authority and major questions doctrine, illustrating judicial oversight of regulatory policy. Practical application, lawyers participate in rulemaking by drafting comments, representing stakeholders, and litigating challenges. Students practice analyzing rulemaking records and drafting comments. They learn to navigate procedural and substantive requirements. 2.3 Stakeholder engagement, lobbying, advocacy, and public participation. Policy formulation involves diverse actors seeking to influence outcomes. Lobbying, direct communication with legislators and agency officials to advocate for specific provisions. Subject to disclosure and ethics rules. Advocacy, public campaigns, media engagement, and grassroots mobilization to shape opinion and pressure decision-makers. Public participation, formal mechanisms, hearings, comments, and informal channels, consultations, partnerships, for stakeholder input. Real-life example, the net neutrality debate involved intense lobbying by telecom companies and tech firms, public advocacy by consumer groups, and FCC rulemaking with millions of comments. This illustrates the multifaceted nature of policy influence. Practical application, lawyers advise clients on lobbying strategies, draft advocacy materials, and ensure compliance with disclosure rules. Students practice stakeholder analysis and engagement planning. They learn to balance advocacy with ethical constraints. 3. Policy implementation and evaluation, administrative action, judicial enforcement, and performance assessment. 3.1 Administrative implementation, discretion, guidance, and enforcement. Agencies translate policy into action through discretionary decisions, interpretive guidance, and enforcement priorities. Discretion: agencies prioritize resources, interpret ambiguous statutes, and adapt to changing circumstances. Discretion must be exercised reasonably and consistently. Guidance: policy statements, interpretive rules, and guidance documents clarify agency expectations without formal rulemaking. These may receive Skidmore deference based on persuasiveness. Enforcement: agencies investigate violations, impose sanctions, and negotiate settlements. Enforcement strategies signal policy priorities and deter noncompliance. Real-life example: SEC enforcement actions against corporate fraud signal policy priorities and shape business conduct. Guidance on cybersecurity disclosure expectations influences corporate practices without formal rulemaking. Practical application: lawyers advise clients on compliance with agency guidance, represent parties in enforcement proceedings, and negotiate settlements. Students practice analyzing agency discretion and enforcement strategies. They learn to navigate informal and formal processes. 3.2 Judicial enforcement, litigation, remedies, and compliance. Courts enforce policy through litigation, providing remedies for violations and ensuring agency accountability. Standing: plaintiffs must demonstrate injury, causation, and redressability to challenge policy. Remedies: injunctions, declaratory judgments, and damages address policy violations. Structural injunctions may reshape institutional practices. Compliance: court orders require ongoing monitoring and adjustment. Non-compliance may trigger contempt sanctions. Real-life example: school desegregation litigation after Brown v. Board involved decades of judicial oversight, structural injunctions, and compliance monitoring. This illustrates the challenges of enforcing transformative policy through litigation. Practical application: lawyers litigate to enforce or challenge policy, draft remedial proposals, and monitor compliance. Students practice standing analysis and remedy design. They learn to balance litigation strategy with implementation realities. 3.3 Policy evaluation, metrics, evidence, and iterative improvement. Effective policy requires systematic evaluation to assess outcomes and inform revision. Metrics: quantitative and qualitative indicators measure policy performance, e.g., coverage rates, cost savings, equity impacts. Evidence: rigorous evaluation methods, randomized trials, quasi-experimental designs, establish causal relationships between policy and outcomes. Iterative improvement: evaluation findings inform policy adjustment, creating a feedback loop for continuous improvement. Real-life example: the evaluation of Medicaid expansion under the ACA used comparative state data to assess impacts on coverage, health outcomes, and state budgets. Findings informed subsequent policy debates and state decisions. Practical application: lawyers advise on evaluation design, interpret findings for policy audiences, and advocate for evidence-based revisions. Students practice policy analysis and evaluation methods. They learn to translate evidence into actionable recommendations. 4. Contemporary issues and professional preparation. 4.1 Polarization and gridlock, challenges to effective policymaking. Political polarization complicates policy formulation and implementation, leading to gridlock, instability, and legitimacy challenges. Gridlock: partisan divisions prevent legislation, forcing reliance on executive action and litigation. Instability: policy reversals across administrations create uncertainty for stakeholders. Legitimacy: perceptions of partisan bias undermine public trust in policy processes. Real-life example: immigration policy has oscillated between administrations through executive orders, litigation, and limited legislation, creating uncertainty for immigrants, employers, and communities. This illustrates the costs of polarization. Practical application: lawyers navigate unstable policy environments by advising on contingency planning, compliance with changing rules, and advocacy for durable solutions. Students analyze polarization dynamics and resilience strategies. They learn to advocate across partisan divides. 4.2 Technology and Policy, Digital Governance, AI Regulation, and Data Rights. Rapid technological change challenges traditional policy frameworks, requiring adaptive governance. Digital governance, regulating platforms, data flows, and digital markets across borders. AI regulation, addressing algorithmic bias, accountability, and innovation incentives. Data rights, balancing privacy, security, and economic value of personal information. Real-life example: the EU's Digital Services Act and AI Act illustrate comprehensive approaches to digital governance, while U.S. sectoral regulation creates a patchwork framework. Lawyers must navigate divergent regimes. Practical application: lawyers advise on technology compliance, advocate for adaptive regulation, and litigate to enforce digital rights. Students analyze technology policy intersections. They learn to balance innovation with protection. 4.3 Learning outcomes and competency benchmarks. By completing public policy and law, students should be able to analyze policy processes and institutional interactions, draft legislation and participate in rulemaking, navigate implementation and enforcement mechanisms, evaluate policy outcomes and advocate for evidence-based reform, address contemporary challenges, polarization, technology. Practical application: these outcomes prepare students for policy advocacy, government service, and public interest law. Mastery ensures effective engagement with the policy law interface. 4.4 Assessment methods, policy briefs, legislative drafting, and simulation exercises. Assessments include: policy briefs, analyze issues and recommend legal interventions. Legislative drafting, draft statutory provisions or amendments. Simulation exercises, role-play legislative hearings or agency rulemaking. Real-life example: a final project might involve drafting a model statute addressing a contemporary issue, e.g., algorithmic accountability, combining policy analysis, legal drafting, and stakeholder consideration. This mirrors real-world policy work. Practical application: students should practice integrated policy law thinking and advocacy skills. 4.5 Transition to capstone and beyond, public policy as foundation for impactful practice. Public policy and law prepares students for the capstone project and careers focused on systemic change. Capstone project integrates policy analysis in a substantial work product. Professional entry equips students to influence policy through multiple channels. Lifelong impact, policy work shapes societies and institutions. Practical application: students should view policy as a lever for legal impact. Mastery ensures meaningful contribution to public problem solving. Slide 11. Year 4, Semester 2, Capstone and Specialization. Course, Law.409, Law of Succession. Foundations of Succession Law, Testamentary Freedom, Family Protection, and Social Policy. 1.1 The nature and purposes of succession law. Succession law governs the transfer of property at death, balancing individual autonomy with family protection and social policy. Understanding these competing values is essential for effective estate planning and dispute resolution. Testamentary freedom: individuals generally have the right to dispose of property as they choose through wills and trusts. This reflects respect for autonomy and incentivizes wealth creation. Family protection: many jurisdictions limit testamentary freedom to protect spouses, children, and dependents from disinheritance. This reflects social commitments to family welfare. Social policy: succession law affects wealth distribution, economic mobility, and intergenerational equity. Tax policies and forced heirship rules reflect broader social choices. Real-life example: in Shapira v. Union National Bank, 1974, a testator conditioned inheritance on his son marrying a Jewish woman within 7 years. The court upheld the condition as a valid exercise of testamentary freedom, illustrating the tension between autonomy and public policy concerns about discrimination. Practical application: lawyers advise clients on balancing testamentary wishes with legal constraints. They draft wills and trusts that achieve client goals while minimizing litigation risks. Students practice analyzing testamentary provisions for validity and enforceability. They learn to navigate jurisdictional variations in succession law. 1.2 Sources of succession law: statutes, common law, and equity. Succession law derives from multiple sources, creating a complex framework for practitioners. Statutes, probate codes, tax laws, and family protection statutes provide the primary framework. These vary significantly across jurisdictions. Common law: judicial decisions interpret statutes and fill gaps, particularly regarding will construction and fiduciary duties. Equity: trust law, developed in courts of equity, provides flexible mechanisms for managing and distributing assets. Real-life example: the Uniform Probate Code, UPC, adopted in many U.S. states, harmonizes succession law but allows local variations. Courts interpret UPC provisions in light of common law principles, illustrating the interplay of sources. Practical application: lawyers must master applicable statutes and case law in their jurisdiction. They research legislative history and judicial trends to advise clients accurately. Students practice statutory interpretation and case analysis in succession contexts. They learn to synthesize multiple legal sources. 1.3 International and comparative perspectives: harmonization and cultural variation. Globalization increases cross-border succession issues, requiring understanding of international frameworks and cultural differences. Harmonization efforts: the Hague Convention on the Law Applicable to Succession, 1989, and EU succession regulation aim to reduce conflicts. Cultural variation: civil law systems often feature forced heirship, common law systems emphasize testamentary freedom. Religious law, e.g., Islamic inheritance rules, influences succession in many jurisdictions. Real-life example: a U.S. citizen with assets in France faces different succession rules, U.S. testamentary freedom versus French forced heirship for children. Planning requires coordination to avoid unintended outcomes. Practical application: lawyers advise on cross-border estate planning, coordinate with foreign counsel, and navigate conflict of laws issues. Students practice analyzing international succession scenarios. They learn to balance client wishes with jurisdictional constraints. 2. Testamentary dispositions, wills, trusts, and alternative mechanisms. 2.1 Will formalities and validity, execution, capacity, and undue influence. Wills must comply with formal requirements to be valid, and testators must possess mental capacity and freedom from coercion. Formalities: most jurisdictions require writing, signature, and attestation by witnesses. Holographic wills, handwritten, are recognized in some places. Capacity: testators must understand the nature of their property, the natural objects of their bounty, and the effect of their disposition. Undue influence: wills procured through coercion or manipulation are invalid. Courts examine suspicious circumstances and beneficiary relationships. Real-life example: in an estate of right, hypothetical, a will leaving everything to a caregiver was challenged based on undue influence. The court examined the testator's vulnerability, the caregiver's control, and the disposition's rationality. This illustrates the fact-intensive nature of undue influence claims. Practical application: lawyers ensure proper will execution, document capacity assessments, and advise on minimizing undue influence risks. Students practice drafting wills and analyzing validity challenges. They learn to anticipate and prevent litigation. 2.2 Will construction and interpretation, ambiguity, extrinsic evidence, and cypress. Courts interpret wills to effectuate testator intent, using various tools when language is ambiguous. Ambiguity: latent ambiguities, unclear application to facts, and patent ambiguities, unclear on face, are treated differently across jurisdictions. Extrinsic evidence. Many courts admit evidence of testator intent to resolve ambiguities, though some restrict such evidence. Press. When a charitable purpose becomes impossible or impracticable, courts may modify the disposition to approximate the testator's intent. Real-life example. In re estate of Russell, hypothetical, a will leaving property to my niece Jane was ambiguous because the testator had two nieces named Jane. The court admitted extrinsic evidence of the testator's relationship to determine intent. This illustrates the role of context in will construction. Practical application. Lawyers draft clear wills to avoid ambiguity, but when disputes arise, they gather evidence of intent and argue for favorable interpretations. Students practice will construction exercises. They learn to balance textualism with intent-based approaches. 2.3 Trusts as succession tools, testamentary trusts, spendthrift provisions, and fiduciary duties. Trusts provide flexible mechanisms for managing and distributing assets after death. Testamentary trusts, created by will, these take effect at death and are subject to probate court oversight. Spendthrift provisions restrict beneficiaries' ability to assign trust interests or creditors' ability to reach trust assets. Fiduciary duties. Trustees must act loyally, prudently, and impartially toward beneficiaries. Real-life example. In Marsman v. Nasca, 1991, a trustee's failure to distribute income as required by the trust instrument led to liability for breach of fiduciary duty. This illustrates the importance of strict compliance with trust terms. Practical application. Lawyers draft trust provisions to achieve client goals while complying with fiduciary standards. They advise trustees on duty compliance and represent beneficiaries in disputes. Students practice trust drafting and fiduciary analysis. They learn to balance flexibility with accountability. 3. Intestate succession and family protection. 3.1 Intestate distribution, statutory schemes and family dynamics. When individuals die without valid wills, intestacy statutes determine distribution, reflecting default social policies. Statutory schemes typically prioritize spouses and children, with varying shares based on family composition. Family dynamics. Intestacy rules may not reflect actual family relationships or testator preferences, leading to unintended outcomes. Reform debates. Some jurisdictions have updated intestacy rules to recognize non-marital partners, stepchildren, and other modern family forms. Real-life example. In many states, if a decedent is survived by a spouse and children from a prior relationship, the spouse receives a share, e.g., 1/3, and children split the remainder. This may conflict with the decedent's likely intent to provide fully for the surviving spouse. Practical application. Lawyers advise clients on the risks of intestacy and encourage estate planning. They represent heirs in intestate proceedings and advocate for statutory reforms. Students practice analyzing intestate distributions. They learn to explain default rules to clients. 3.2 Spousal and child protections, elective shares, pretermitted heirs, and family allowances. Many jurisdictions limit testamentary freedom to protect close family members. Elective shares. Surviving spouses may elect a statutory share, e.g., 1/3 of the estate, regardless of will provisions. Pretermitted heirs. Children born or adopted after a will's execution may receive a share unless the will shows intent to disinherit. Family allowances. Temporary support for surviving spouses and minor children during probate. Real-life example. In estate of Hillowitz, hypothetical, a testator left everything to a charity, disinheriting his spouse. The spouse elected her statutory share, reducing the charitable bequest. This illustrates the tension between testamentary freedom and spousal protection. Practical application. Lawyers advise clients on the limits of disinheritance and draft wills that account for elective shares. They represent spouses and children in protection claims. Students practice analyzing family protection statutes. They learn to balance client wishes with legal constraints. 3.3 Non-probate transfers, joint tenancy, life insurance, and retirement accounts. Many assets pass outside probate through non-testamentary mechanisms, affecting succession planning. Joint tenancy with right of survivorship, property passes automatically to the surviving joint tenant. Life insurance and retirement accounts, beneficiary designations control distribution, superseding will provisions. Payable on death and transfer on death designations, allow assets to pass directly to named beneficiaries. Real-life example, a testator's will leaving all my property to my children may be ineffective for a joint bank account with right of survivorship naming the spouse. This illustrates the importance of coordinating probate and non-probate transfers. Practical application, lawyers advise clients on aligning beneficiary designations with estate plans. They analyze conflicts between wills and non-probate transfers. Students practice integrated estate planning. They learn to avoid unintended disinheritance. 4. Contemporary issues and professional preparation. 4.1 Digital assets and succession, access, privacy, and fiduciary authority. Technology creates new challenges for succession law, as digital assets, social media, cryptocurrencies, cloud storage, raise questions of access, privacy, and control. Access issues, passwords, encryption, and terms of service may prevent fiduciaries from accessing digital assets. Privacy concerns, decedent's privacy interests may conflict with beneficiaries' rights to access information. Fiduciary authority, statutes like the revised Uniform Fiduciary Access to Digital Assets Act, RFADA, provide frameworks for fiduciary access. Real-life example, in re Ellsworth, hypothetical, an executor sought access to a decedent's email account to locate estate documents. The court balanced the executor's need against the decedent's privacy expectations and the provider's terms of service. Practical application, lawyers advise clients on digital asset planning, including inventorying assets, providing access instructions, and designating digital fiduciaries. They navigate RFADA and provider policies. Students practice drafting digital asset provisions. They learn to address emerging succession issues. 4.2 Blended families and non-traditional relationships, planning challenges and legal recognition. Changing family structures create complexity for succession planning. Blended families, stepchildren, half-siblings, and multiple marriages require careful drafting to achieve intended distributions. Non-traditional relationships, unmarried partners, polyamorous relationships, and chosen family may lack legal recognition, requiring creative planning. Legal recognition, some jurisdictions recognize domestic partnerships or allow contractual arrangements to mimic spousal rights. Real-life example, in a blended family, a testator may wish to provide for a surviving spouse during life but ensure children from a prior relationship inherit the remainder. This requires sophisticated trust planning to balance competing interests. Practical application, lawyers advise clients on family dynamics and draft instruments that reflect complex relationships. They advocate for legal recognition of non-traditional families. Students practice planning for diverse family structures. They learn to navigate emotional and legal complexities. 4.3 Learning outcomes and competency benchmarks. By completing law of succession, students should be able to navigate testamentary and intestate succession frameworks, draft wills, trusts, and non-probate transfer mechanisms, advise on family protection and cross-border issues, address contemporary challenges, digital assets, blended families. Practical application, these outcomes prepare students for estate planning, probate litigation, and elder law practice. Mastery ensures effective succession counseling. 4.4 Assessment methods, estate planning exercises, will contests, and comparative analysis. Assessments include estate planning exercises, draft comprehensive estate plans for hypothetical clients. Will contests, analyze validity challenges and construction disputes. Comparative analysis, evaluate succession rules across jurisdictions. Real-life example, a final project might involve planning for a client with digital assets, a blended family, and international property, requiring integration of multiple succession concepts. This mirrors complex estate planning practice. Practical application: students should practice holistic planning and dispute resolution skills. 4.5 Transition to capstone and beyond: succession law as foundation for elder law and wealth management. Law of succession prepares students for the capstone project and careers in estate planning and wealth management. Capstone project integrates succession analysis in a substantial work product. Professional entry equips students to handle complex estate matters. Lifelong relevance: succession law affects families, wealth, and legacy. Practical application: students should view succession law as a critical practice area. Mastery ensures effective client service and legacy planning. Slide 11. Year 4, Semester 2, Capstone and Specialization. Course, Law.410, Animal Law. Foundations of Animal Law, Ethical Frameworks, Legal Status, and Historical Evolution. 1.1 Ethical Foundations, Animal Welfare, Rights, and Liberation. Animal law is grounded in ethical debates about human obligations to non-human animals. Understanding these frameworks is essential for analyzing legal doctrines and advocating for reform. Animal welfare focuses on minimizing suffering while permitting human use of animals. Emphasizes humane treatment standards. Animal rights argues that animals possess inherent moral value and should not be treated as property. Emphasizes legal personhood or protected interests. Animal liberation seeks to end human exploitation of animals, often through abolitionist approaches. Real-life example: the Animal Welfare Act, 1966, reflects a welfare approach, setting minimum standards for animal treatment in research and exhibition. In contrast, the Non-Human Rights Project's litigation seeking habeas corpus for chimpanzees reflects a rights-based strategy. These divergent approaches illustrate the ethical spectrum in animal law. Practical application: lawyers must understand ethical frameworks to craft persuasive arguments, whether advocating for stronger welfare regulations or challenging animal exploitation. Students practice analyzing cases through different ethical lenses. They learn to bridge ethical theory and legal strategy. 1.2 Legal status of animals, property, sentient beings, and emerging personhood. Animals' legal status shapes the rights and remedies available in animal law cases. Property status: traditionally, animals are classified as personal property, limiting recovery to market value in tort cases and restricting standing to bring claims. Sentient beings: some jurisdictions recognize animals as sentient beings with intrinsic value, affecting statutory interpretation and damages. Emerging personhood: litigation and legislation increasingly explore legal personhood or quasi-personhood for certain animals, particularly great apes and cetaceans. Real-life example: in Re Non-Human Rights Project Incorporated v. Lavery, 2018, the New York Court of Appeals declined to grant habeas corpus to a chimpanzee, reaffirming property status but acknowledging evolving ethical considerations. This illustrates the tension between traditional doctrine and emerging norms. Practical application: lawyers navigate property status limitations while advocating for expanded protections. They draft legislation recognizing animal sentience and litigate to establish new precedents. Students practice analyzing property law doctrines in animal contexts. They learn to leverage statutory and constitutional hooks for reform. 1.3 Historical evolution: from anti-cruelty statutes to comprehensive regulation. Animal law has evolved from narrow anti-cruelty provisions to comprehensive regulatory frameworks. Anti-cruelty statutes: early laws prohibited gratuitous cruelty to animals, often with limited enforcement. Welfare regulations: 20th-century laws expanded to cover farming, research, and entertainment, setting standards for treatment. Contemporary developments: recent decades have seen increased recognition of animal interests, with laws addressing companion animals, wildlife conservation, and animal enterprise terrorism. Real-life example: The evolution of U.S. animal law from the 1828 New York Anti-Cruelty Statute to the Federal Animal Welfare Act and state AG-gag laws illustrates shifting societal values and political dynamics. Practical application: lawyers advising on animal issues must understand historical context to interpret current doctrines and advocate for reform. Students analyze historical cases and statutes to trace doctrinal evolution. They learn to use history strategically in advocacy. 2. Substantive areas: companion animals, farm animals, wildlife, and research. 2.1 Companion animal law, custody, liability, and welfare. Companion animals raise unique legal issues involving family law, torts, and statutory protections. Custody disputes: courts increasingly consider animals' best interests in divorce and separation cases, moving beyond property division. Liability: owners may be liable for animal bites or property damage under strict liability or negligence theories. Welfare protections: anti-cruelty laws, shelter regulations, and breeding restrictions protect companion animals. Real-life example: in Travis v. Murray, 2013, a New York court applied a best for all concerned standard to resolve a dog custody dispute, considering the animal's well-being alongside human interests. This illustrates the evolving approach to companion animal status. Practical application: lawyers represent clients in custody disputes, defend liability claims, and advocate for welfare legislation. Students practice analyzing companion animal cases. They learn to balance human and animal interests. 2.2 Farm animal law, agricultural practices, welfare standards, and consumer protection. Farm animal law intersects with agriculture, food policy, and consumer rights. Agricultural practices, laws regulate confinement, slaughter, and transportation of farm animals. Welfare standards, statutes and certification programs set minimum treatment requirements. Consumer protection, labeling laws, e.g., free-range, humane, and fraud claims affect market dynamics. Real-life example: California's Proposition 12, 2018, established space requirements for egg-laying hens, breeding pigs, and veal calves, affecting national supply chains. This illustrates how state welfare laws can have broad economic impacts. Practical application: lawyers advise agricultural businesses on compliance, represent advocates in challenges to practices, and litigate labeling disputes. Students practice analyzing farm animal regulations. They learn to navigate agricultural policy and market forces. 2.3 Wildlife law, conservation, habitat protection, and human-wildlife conflict. Wildlife law balances species protection with human interests in land use and resource development. Conservation statutes, Endangered Species Act, Migratory Bird Treaty Act, and international conventions protect species and habitats. Habitat protection, land use regulations and conservation easements preserve critical ecosystems. Human-wildlife conflict, laws address predation, disease transmission, and property damage. Real-life example: in Tennessee Valley Authority v. Hill, 1978, the Supreme Court halted a dam project to protect the endangered snail darter, illustrating the strength of species protection statutes. Subsequent amendments balanced conservation with development. Practical application: lawyers represent agencies, conservation groups, and landowners in wildlife disputes. They navigate permitting processes and litigate to enforce protections. Students practice analyzing conservation statutes. They learn to balance ecological and human needs. 2.4 Animals in research, regulation, ethics, and alternatives. Animal research is governed by complex regulatory and ethical frameworks. Regulatory oversight, Animal Welfare Act, Public Health Service Policy, and Institutional Animal Care and Use Committees, IACUCs, oversee research. Ethical debates, balancing scientific progress with animal welfare raises questions about necessity, alternatives, and suffering. Alternatives development, laws and policies encourage development of non-animal research methods. Real-life example: The NIH's requirement to consider alternatives to animal use in research proposals illustrates the integration of ethical considerations into regulatory frameworks. Practical application: lawyers advise research institutions on compliance, represent advocates in challenges to practices, and litigate to enforce standards. Students practice analyzing research regulations. They learn to navigate scientific and ethical complexities. 3. Enforcement and remedies: criminal prosecution, civil litigation, and administrative action. 3.1 Criminal prosecution, anti-cruelty laws and enforcement challenges. Criminal law is a primary tool for addressing animal abuse, but enforcement faces significant challenges. Anti-cruelty statutes define prohibited conduct, mental states, and penalties. Variations across jurisdictions create enforcement disparities. Enforcement challenges: limited resources, evidentiary difficulties, and cultural attitudes affect prosecution rates. Sentencing and remedies: courts may order restitution, probation conditions, and animal forfeiture. Real-life example: high-profile animal cruelty cases often receive media attention, increasing public pressure for prosecution. However, routine cases may be deprioritized due to resource constraints. Practical application: lawyers prosecute or defend animal cruelty cases, advise on investigation techniques, and advocate for stronger enforcement. Students practice analyzing criminal statutes and evidentiary issues. They learn to navigate criminal procedure in animal contexts. 3.2 Civil litigation, torts, contracts, and statutory claims. Civil remedies provide additional avenues for protecting animal interests. Tort claims: negligence, intentional infliction of emotional distress, and conversion may apply to animal-related harms. Contract disputes: breach of contract claims arise in veterinary malpractice, breeding agreements, and pet sales. Statutory claims: some laws create private rights of action for animal welfare violations. Real-life example: in Bachelor vs. South Hills Veterinary Hospital, hypothetical, a pet owner sued for veterinary malpractice after a dog died during surgery. The court analyzed standard of care and damages, illustrating tort principles in animal contexts. Practical application: lawyers represent plaintiffs and defendants in civil animal cases, draft contracts involving animals, and litigate statutory claims. Students practice civil litigation skills in animal law scenarios. They learn to calculate damages and prove causation. 3.3 Administrative action, agency rulemaking, permitting, and enforcement. Administrative agencies play crucial roles in implementing animal protection laws. Rulemaking: agencies issue regulations interpreting statutes and setting standards. Permitting: licenses for research, exhibition, and transportation of animals require compliance with welfare standards. Enforcement: agencies investigate violations, impose sanctions, and negotiate settlements. Real-life example: USDA inspections of research facilities under the Animal Welfare Act illustrate administrative enforcement. Violations may result in fines, license suspension, or criminal referral. Practical application: lawyers participate in rulemaking comments, represent clients in permitting processes, and defend against enforcement actions. Students practice administrative law skills in animal contexts. They learn to navigate agency procedures and standards. 4. Contemporary issues and professional preparation. 4.1 Emerging frontiers, animal personhood, environmental law, and technology. Animal law is evolving rapidly, with new legal theories and technological developments creating opportunities and challenges. Animal personhood: litigation seeking legal personhood for great apes, elephants, and cetaceans challenges traditional property status. Environmental law intersection: animal welfare intersects with habitat protection, climate change, and biodiversity conservation. Technology impacts: genetic engineering, lab-grown meat, and surveillance technologies affect animal law doctrines. Real-life example: the Non-Human Rights Project's habeas corpus petitions for chimpanzees illustrate the personhood frontier. While unsuccessful so far, these cases have shifted public discourse and legal analysis. Practical application: lawyers advocate for innovative legal theories, advise on technology compliance, and litigate to establish new precedents. Students practice analyzing emerging issues. They learn to balance innovation with ethical considerations. 4.2 Global perspectives: international law, comparative approaches, and transnational advocacy. Animal protection is increasingly a global concern, requiring understanding of international frameworks and comparative approaches. International law, conventions on wildlife trade, CITES, animal welfare, OIE standards, and biodiversity, CBD, create transnational obligations. Comparative approaches: different jurisdictions adopt varying levels of animal protection, reflecting cultural, economic, and political factors. Transnational advocacy: NGOs and advocates coordinate across borders to promote animal welfare standards. Real-life example: the EU's comprehensive animal welfare regulations, including bans on battery cages and cosmetic testing, influence global standards through trade relationships and advocacy. Practical application: lawyers advise on international compliance, represent clients in cross-border disputes, and advocate for harmonized standards. Students practice comparative analysis. They learn to navigate cultural and legal diversity. 4.3 Learning outcomes and competency benchmarks. By completing animal law, students should be able to analyze ethical frameworks and legal status of animals, navigate substantive areas, companion, farm, wildlife, research, pursue enforcement through criminal, civil, and administrative channels, address emerging issues, personhood, technology, globalization. Practical application: these outcomes prepare students for animal advocacy, government service, and specialized practice. Mastery ensures effective representation of animal interests. 4.4 Assessment methods: case studies, legislative drafting, and advocacy projects. Assessments include: case studies, analyze landmark animal law decisions. Legislative drafting, draft model animal protection statutes. Advocacy projects, design campaigns or litigation strategies for animal issues. Real-life example: a final project might involve advocating for a local ordinance protecting urban wildlife, combining legal analysis, policy drafting, and community engagement. This mirrors real-world animal law practice. Practical application: students should practice integrated advocacy and legal skills. 4.5 Transition to capstone and beyond: animal law as foundation for advocacy and policy. Animal law prepares students for the capstone project and careers focused on animal protection. Capstone project integrates animal law analysis in a substantial work product. Professional entry equips students to handle complex animal-related matters. Lifelong impact: animal law shapes human-animal relationships and ethical progress. Practical application: students should view animal law as a dynamic field for advocacy. Mastery ensures meaningful contribution to animal welfare. Slide 11. Year 4, Semester 2, Capstone and Specialization. Course, Law.411, International Environmental Law. Foundations of International Environmental Law, Principles, Sources, and Institutions. 1.1 Core Principles: Sustainable Development, Precaution, and Common but Differentiated Responsibilities. International Environmental Law, IEL, is guided by foundational principles that shape treaty interpretation, state obligations, and dispute resolution. Sustainable development balances economic growth, social equity, and environmental protection. Embodied in the Brundtland Report and Rio Declaration. Precautionary principle requires preventive action in the face of scientific uncertainty to avoid serious or irreversible harm. Common but differentiated responsibilities, CBDR recognizes that while all states share responsibility for environmental protection, developed countries bear greater historical responsibility and capacity. Real-life example: the Paris Agreement, 2015, embodies sustainable development by linking climate action to poverty eradication. Its nationally determined contributions reflect CBDR by allowing differentiated commitments based on national circumstances. The precautionary principle underpins regulations on genetically modified organisms and chemical safety. Practical application: lawyers advising states or NGOs on environmental treaties must understand these principles to interpret obligations and advocate for compliance. Students practice applying principles to treaty texts and state practice. They learn to leverage principles in negotiations and litigation. 1.2 Sources of international environmental law, treaties, custom, and soft law. IEL derives from diverse sources, creating a complex normative framework. Treaties, multilateral environmental agreements, MEAs, like the UNFCCC, CBD, and Montreal Protocol establish binding obligations. Customary international law, principles like no harm, states must not cause transboundary environmental harm, and sustainable use of shared resources may attain customary status. Soft law, declarations, guidelines, and action plans, e.g., Rio Declaration, Agenda 21, influence state behavior and treaty development without binding force. Real-life example: the Trail Smelter Arbitration, 1941, established the no-harm principle as customary law, requiring states to prevent transboundary pollution. This principle now underpins numerous treaties and judicial decisions. Practical application: lawyers identify applicable sources in transboundary disputes, advise on treaty compliance, and advocate for customary norm recognition. Students practice analyzing source hierarchies and interactions. They learn to navigate binding and non-binding instruments. 1.3 Institutional architecture, UNEP, treaty secretariats, and compliance mechanisms. IEL is implemented through a network of international institutions. United Nations Environment Programme, UNEP coordinates global environmental governance, provides scientific assessments, and facilitates treaty negotiations. Treaty secretariats, administrative bodies for MEAs, e.g., UNFCCC Secretariat, that organize conferences, manage reporting, and support implementation. Compliance mechanisms, non-confrontational procedures, e.g., facilitative branches, and judicial forums, e.g., ICJ, ITLOs, address non-compliance. Real-life example: the Montreal Protocol's Implementation Committee reviews party reports, provides assistance, and recommends measures for non-compliance. This illustrates the blend of facilitation and enforcement in IEL institutions. Practical application: lawyers represent states or NGOs in treaty bodies, advise on reporting obligations, and participate in compliance proceedings. Students practice navigating institutional processes. They learn to leverage institutional forums for advocacy. 2. Substantive regimes, climate change, biodiversity, and pollution control. 2.1 Climate Change Law, UNFCCC, Paris Agreement, and carbon markets. Climate change is the most prominent IEL issue, governed by a complex regime. UNFCCC framework establishes principles, institutions, and processes for climate cooperation. Paris Agreement sets global temperature goals, requires nationally determined contributions, NDCs, and creates transparency and stocktake mechanisms. Carbon markets. Article 6 of the Paris Agreement enables international cooperation through emissions trading and mitigation outcomes. Real-life example: the Paris Agreement's ratchet mechanism requires parties to progressively enhance NDCs every 5 years. This dynamic approach addresses the inadequacy of initial commitments. Carbon market rules under Article 6 aim to reduce mitigation costs while ensuring environmental integrity. Practical application: lawyers advise governments on NDC design, represent parties in climate negotiations, and litigate to enforce climate obligations. Students practice analyzing treaty provisions and implementation strategies. They learn to navigate the intersection of law, science, and politics. 2.2 Biodiversity conservation, CBD, sites, and protected areas. Biodiversity loss is addressed through multiple overlapping regimes. Convention on Biological Diversity, CBD sets objectives for conservation, sustainable use, and fair benefit sharing of genetic resources. CITES regulates international trade in endangered species through permit systems. Protected areas, international designations, World Heritage, Ramsar, and national parks conserve critical habitats. Real-life example, the Nagoya Protocol, 2010, under the CBD establishes rules for access to genetic resources and benefit sharing, affecting biotechnology and pharmaceutical industries. This illustrates how biodiversity law intersects with economic interests. Practical application, lawyers advise on compliance with access and benefit sharing rules, represent parties in CITES enforcement, and litigate to protect habitats. Students practice analyzing biodiversity treaties. They learn to balance conservation with development. 2.3 Pollution control, marine, air, and hazardous substances. IEL addresses pollution through sectoral and cross-media approaches. Marine pollution, MARPOL regulates vessel source pollution, London Convention addresses dumping, UNCLOS provides general obligations. Air pollution, Long-Range Transboundary Air Pollution Convention and regional protocols reduce acid rain and particulate matter. Hazardous substances, Basel, Rotterdam, and Stockholm Conventions regulate waste trade, chemical trade, and persistent organic pollutants. Real-life example, the Minamata Convention on Mercury, 2013, illustrates comprehensive regulation of a hazardous substance, covering mining, trade, emissions, and waste. This shows how IEL addresses global pollutant cycles. Practical application, lawyers advise industries on pollution control compliance, represent states in transboundary disputes, and advocate for stronger regulations. Students practice analyzing pollution regimes. They learn to navigate technical and legal complexities. 3. Implementation and enforcement, national action, international cooperation, and dispute resolution. 3.1 National implementation, legislation, regulation, and judicial enforcement. IEL relies on national action for implementation, creating challenges for consistency and effectiveness. Legislation, states enact laws to transpose treaty obligations into domestic law. Regulation, agencies issue rules, permits, and standards to operationalize legislation. Judicial enforcement, courts interpret environmental laws, review agency action, and provide remedies for violations. Real-life example, the EU's implementation of the Paris Agreement through the European climate law illustrates supranational transposition. National courts in the Netherlands, Urgenda, and Germany have ordered governments to enhance climate action based on human rights and constitutional law. Practical application, lawyers advise governments on legislative drafting, represent regulated entities in compliance matters, and litigate to enforce environmental laws. Students practice analyzing implementation strategies. They learn to bridge international and domestic law. 3.2 International cooperation, finance, technology transfer, and capacity building. IEL recognizes that effective implementation requires support for developing countries. Climate finance, Green Climate Fund and other mechanisms mobilize resources for mitigation and adaptation. Technology transfer, treaties promote sharing of environmentally sound technologies. Capacity building, training, institutional strengthening, and knowledge exchange enhance implementation capabilities. Real-life example, the Global Environment Facility, GEF, provides funding for biodiversity, climate, and land degradation projects in developing countries. This illustrates the financial architecture supporting IEL. Practical application, lawyers advise on access to international funds, negotiate technology transfer agreements, and design capacity building programs. Students practice analyzing cooperation mechanisms. They learn to leverage international support for national action. 3.3 Dispute resolution, diplomatic, judicial, and arbitral forums. IEL disputes may be resolved through multiple forums. Diplomatic means, negotiation, mediation, and good offices through treaty bodies or third parties. Judicial forums, ICJ, ITLOS, and regional courts adjudicate environmental disputes. Arbitral mechanisms, Permanent Court of Arbitration's environmental rules and ad hoc tribunals provide flexible dispute resolution. Real-life example, the whaling in the Antarctic case, 2014, before the ICJ interpreted the International Convention for the Regulation of Whaling, illustrating judicial resolution of environmental disputes. The South China Sea arbitration addressed marine environmental obligations under UNCLOS. Practical application, lawyers represent parties in environmental disputes, draft submissions, and advise on forum selection. Students practice dispute resolution skills in environmental contexts. They learn to navigate jurisdictional and substantive issues. 4. Contemporary issues and professional preparation. 4.1 Climate litigation and human rights, strategic advocacy and judicial innovation. Climate litigation is expanding globally, using human rights frameworks to compel action. Strategic litigation, cases target governments and corporations to enforce climate obligations. Human rights integration, courts recognize that climate change threatens rights to life, health, and property. Judicial innovation, courts develop new doctrines, e.g., intergenerational equity, precautionary principle, to address climate challenges. Real-life example, in Urgenda Foundation vs. Netherlands, 2019, the Dutch Supreme Court ordered the government to reduce emissions based on human rights obligations. This illustrates the potential of rights-based climate litigation. Practical application, lawyers design strategic litigation campaigns, draft human rights-based arguments, and advise clients on climate risk disclosure. Students practice analyzing climate cases. They learn to leverage judicial innovation for systemic change. 4.2 Planetary boundaries and Earth system governance, beyond traditional frameworks. Emerging concepts challenge traditional IEL approaches. Planetary boundaries, scientific framework identifying safe operating spaces for humanity across 9 Earth system processes. Earth system governance, proposes integrated, adaptive governance for complex socio-ecological systems. Legal implications, requires rethinking sovereignty, jurisdiction, and intergenerational equity. Real-life example, proposals for a global pact for the environment aim to codify foundational principles, illustrating efforts to strengthen IEL's normative framework. Practical application, lawyers advise on emerging governance models, advocate for systemic reforms, and litigate to enforce planetary boundaries. Students practice analyzing cutting-edge concepts. They learn to bridge science, law, and policy. 4.3 Learning outcomes and competency benchmarks. By completing international environmental law, students should be able to navigate IEL principles, sources, and institutions. Analyze substantive regimes, climate, biodiversity, pollution. Implement and enforce obligations through national and international mechanisms. Address contemporary challenges, climate litigation, planetary boundaries. Practical application, these outcomes prepare students for environmental advocacy, government service, and international practice. Mastery ensures effective engagement with global environmental governance. 4.4 Assessment methods, treaty analysis, policy briefs, and moot court. Assessments include treaty analysis, evaluate provisions and implementation of MEAs. Policy briefs, recommend legal strategies for environmental challenges. Moot court, simulate environmental dispute resolution before international tribunals. Real-life example, a final project might involve drafting a model treaty provision addressing a gap in climate governance, combining legal analysis, policy design, and negotiation strategy. This mirrors real-world treaty work. Practical application, students should practice integrated legal policy thinking and advocacy skills. 4.5 Transition to capstone and beyond, IEL as foundation for global environmental practice. International environmental law prepares students for the capstone project and careers in environmental law and policy. Capstone project, integrates IEL analysis in a substantial work product. Professional entry, equips students to handle complex transnational environmental matters. Global impact, IEL shapes planetary sustainability and intergenerational justice. Practical application: students should view IEL as a critical framework for global challenges. Mastery ensures impactful advocacy for environmental protection. Slide 11. Year 4, Semester 2, Capstone and Specialization. Course, Law. 412, Real Estate Law. Foundations of Real Estate Law, Property Interests, Transactions, and Regulatory Frameworks. 1.1 Property Interests in Land, Estates, Future Interests, and Concurrent Ownership. Real estate law governs the creation, transfer, and enforcement of interests in land. Understanding these interests is foundational for transactions, development, and dispute resolution. Estates in land: fee simple absolute, maximum ownership, life estate, duration of a life, and leasehold, possessory interest for a term, define the duration and quality of ownership rights. Future interests, reversions, remainders, and executory interests represent rights to possess property at a later time, subject to rules against perpetuities. Concurrent ownership, joint tenancy, with right of survivorship, tenancy in common, undivided shares, and tenancy by the entirety, for married couples, govern co-ownership. Real-life example, in White v. Brown, 1947, a will granting property, to my sister for her life, then to her children, created a life estate with remainder, illustrating future interest creation. Proper drafting avoids ambiguities that lead to litigation. Practical application: lawyers draft deeds and wills to create specific estates, advise on co-ownership structures, and litigate interest disputes. Students practice classifying estates and future interests. They learn to avoid perpetuities violations and drafting errors. 1.2 Real estate transactions, contracts, title, and closing procedures. Real estate transactions follow a structured process from contract to closing. Purchase agreements define price, contingencies, financing, inspection, title, and closing terms. Statute of frauds requires written contracts. Title examination: search public records to identify defects, liens, and encumbrances. Title insurance protects against undiscovered defects. Closing procedures: settlement involves payment, deed delivery, recording, and proration of expenses. Real-life example, in Centex Homes v. Bucher, 2004, the court enforced a liquidated damages clause in a home purchase contract, illustrating remedy limitations. Proper contingency drafting protects buyers from unforeseen risks. Practical application: lawyers draft purchase agreements, conduct title searches, and manage closings. Students practice transaction checklists and risk allocation. They learn to balance client protection with deal feasibility. 1.3 Regulatory frameworks: zoning, land use, and environmental compliance. Real estate development is subject to extensive regulation. Zoning ordinances divide municipalities into districts with permitted uses, densities, and building standards. Land use controls, subdivision regulations, historic preservation, and impact fees shape development. Environmental compliance, wetlands, endangered species, and contamination regulations affect property use and value. Real-life example, in Village of Euclid v. Ambler Realty Company, 1926, the Supreme Court upheld zoning as a valid exercise of police power, establishing the foundation for modern land use regulation. Developers must navigate zoning approvals before construction. Practical application: lawyers advise on zoning variances, represent clients in land use hearings, and ensure environmental compliance. Students practice analyzing regulatory constraints. They learn to balance development goals with community interests. 2. Financing and security interests, mortgages, liens, and foreclosure. 2.1 Mortgage law, creation, priority, and enforcement. Mortgages secure real estate loans, creating complex rights and obligations. Creation: mortgages require a debt obligation, security interest in property, and proper execution/recording. Priority: recording statutes, notice, race notice, determine lien priority among competing claims. Enforcement, foreclosure, judicial or power of sale, allows lenders to recover debt from property value. Real-life example, in Rest Realty Corporation v. Cooper, 1969, the court analyzed constructive eviction doctrines in mortgage contexts, illustrating the intersection of property and contract law. Proper priority analysis prevents lending disputes. Practical application, lawyers draft mortgage documents, conduct lien searches, and represent parties in foreclosure. Students practice priority analysis and foreclosure procedures. They learn to protect lender and borrower rights. 2.2 Alternative financing, sale-leasebacks, ground leases, and mezzanine debt. Creative financing structures address diverse real estate needs. Sale-leasebacks, owners sell property and lease it back, freeing capital while retaining use. Ground leases, long-term leases of land for development, separating land and building ownership. Mezzanine debt, subordinate financing secured by ownership interests rather than real property. Real-life example, ground leases in urban development allow developers to build on land they do not own, with complex provisions for rent adjustments, improvements, and termination. This illustrates the flexibility of real estate financing. Practical application, lawyers structure alternative financing, draft complex agreements, and advise on tax and accounting implications. Students practice analyzing financing structures. They learn to balance risk and return. 2.3 Distressed real estate, workouts, foreclosure defense, and bankruptcy. Economic downturns create opportunities and challenges in distressed real estate. Workouts, negotiated modifications of loan terms to avoid foreclosure. Foreclosure defense, borrowers challenge procedural defects, assert counterclaims, or seek bankruptcy protection. Bankruptcy, Chapter 11 reorganization or Chapter 7 liquidation affects real estate interests and creditor rights. Real-life example, during the 2008 financial crisis, many homeowners sought foreclosure defense based on robo-signing and documentation errors. Courts scrutinized lender compliance with procedural requirements. Practical application, lawyers represent borrowers and lenders in distressed situations, negotiate workouts, and litigate foreclosure defenses. Students practice distressed asset analysis. They learn to navigate financial and legal complexities. 3. Landlord-tenant law and property management. 3.1 Lease agreements, terms, covenants, and remedies. Leases govern landlord-tenant relationships, balancing possession rights with property protection. Key terms, rent, duration, use restrictions, maintenance responsibilities, and renewal options. Covenants, implied warranty of habitability, quiet enjoyment, and repair obligations. Remedies, eviction, rent withholding, repair and deduct, and damages for breach. Real-life example, in Javins v. First National Realty Corporation, 1970, the D.C. Circuit recognized the implied warranty of habitability, allowing tenants to withhold rent for uninhabitable conditions. This shifted the balance toward tenant protections. Practical application, lawyers draft leases, advise on covenant compliance, and represent parties in eviction or breach disputes. Students practice lease negotiation and remedy analysis. They learn to balance landlord and tenant interests. 3.2 Property management, operations, compliance, and risk management. Property managers oversee day-to-day operations, requiring legal knowledge across multiple domains. Operations, tenant screening, rent collection, maintenance, and vendor management. Compliance, fair housing, building codes, safety regulations, and environmental laws. Risk management, insurance, liability prevention, and dispute resolution. Real-life example, Fair Housing Act compliance requires non-discriminatory tenant screening and reasonable accommodations for disabilities. Violations can result in significant damages and injunctive relief. Practical application, lawyers advise property managers on compliance, draft policies, and defend against discrimination claims. Students practice analyzing management scenarios. They learn to prevent and resolve disputes. 3.3 Commercial versus residential leasing, distinct legal frameworks. Commercial and residential leases are governed by different legal regimes. Commercial leasing, greater freedom of contract, with parties negotiating terms like CAM charges, exclusivity, and assignment rights. Residential leasing, more regulatory protection for tenants, including rent control, eviction procedures, and habitability standards. Hybrid uses, mixed-use properties require careful drafting to address both regimes. Real-life example, in commercial leases, triple net, NNN, structures pass operating expenses to tenants, while residential leases typically include these in rent. Understanding these differences is crucial for drafting and negotiation. Practical application, lawyers specialize in commercial or residential leasing, or handle both with awareness of distinct frameworks. Students practice drafting leases for different property types. They learn to tailor terms to use and jurisdiction. 4. Contemporary issues and professional preparation. 4.1 Sustainable development and green building, LEED, energy efficiency, and climate resilience. Real estate law increasingly addresses environmental sustainability. Green building standards, LEED certification, energy codes, and water conservation requirements. Energy efficiency, benchmarking, retrofits, and renewable energy integration. Climate resilience, flood zones, sea level rise, and extreme weather affect property values and insurance. Real-life example, local ordinances requiring energy benchmarking and disclosure, e.g., NYC Local Law 84, affect commercial property operations. Lawyers advise on compliance and liability risks. Practical application, lawyers advise on sustainable development incentives, draft green lease provisions, and litigate climate-related property disputes. Students practice analyzing sustainability regulations. They learn to integrate environmental considerations into real estate practice. 4.2 Technology and real estate, PropTech, smart buildings, and data privacy. Technology transforms real estate transactions and management. PropTech, online listings, virtual tours, and blockchain for title records streamline processes. Smart buildings, IoT devices for energy management, security, and tenant services raise data and liability issues. Data privacy, tenant and buyer information collection requires compliance with privacy laws. Real-life example, blockchain-based title systems promise to reduce fraud and transaction costs, but legal recognition and standardization remain challenges. Lawyers must navigate emerging technologies while ensuring legal compliance. Practical application, lawyers advise on technology adoption, draft data protection policies, and litigate PropTech disputes. Students practice analyzing technology law intersections. They learn to balance innovation with risk management. 4.3 Learning outcomes and competency benchmarks. By completing real estate law, students should be able to navigate property interests and transactional frameworks, structure financing and security arrangements, advise on landlord-tenant and property management issues, address contemporary challenges, sustainability, technology. Practical application, these outcomes prepare students for real estate practice, development counseling, and property management. Mastery ensures effective representation in complex property matters. 4.4 Assessment methods, transaction simulations, title analysis, and development projects. Assessments include transaction simulations, draft and negotiate purchase agreements and leases. Title analysis, identify defects and recommend curative actions. Development projects, analyze zoning, financing, and regulatory compliance for hypothetical developments. Real-life example, a final project might involve structuring a mixed-use development, combining land use, financing, leasing, and sustainability considerations. This mirrors real-world real estate practice. Practical application, students should practice integrated transactional and regulatory thinking. 4.5 Transition to capstone and beyond, real estate law as foundation for development and investment. Real estate law prepares students for the capstone project and careers in real estate development, finance, and counseling. Capstone project integrates real estate analysis in a substantial work product. Professional entry equips students to handle complex property transactions and disputes. Economic impact, real estate law shapes communities, investments, and wealth creation. Practical application, students should view real estate law as a dynamic practice area. Mastery ensures versatile and impactful representation. Slide 11. Year 4, Semester 2, Capstone and Specialization. Course, Law. 413, Law and Economics. Foundations of Law and Economics, Theoretical Frameworks and Methodological Approaches. 1.1 Core Concepts, Efficiency, Incentives, and Transaction Costs. Law and Economics applies economic analysis to legal rules and institutions, focusing on how law shapes behavior and allocates resources. Efficiency, legal rules should maximize social wealth or welfare. Pareto efficiency, no one worse off, and Kaldor-Hicks efficiency, gains outweigh losses, provide evaluative standards. Incentives, law creates incentives for behavior through liability rules, property rights, and sanctions. Rational actors respond to these incentives. Transaction costs, costs of bargaining, information, and enforcement affect whether private ordering or legal intervention is preferable. Real-life example, in United States v. Carroll Towing Company, 1947, Judge Hand's formula, BPL, for negligence reflects economic reasoning. Liability should attach when the burden of precautions is less than the probability of harm multiplied by its magnitude. This illustrates how economic analysis informs legal standards. Practical application, lawyers use economic reasoning to argue for efficient rules, design contracts that align incentives, and advise clients on risk management. Students practice applying efficiency concepts to legal doctrines. They learn to balance economic and non-economic values. 1.2 Methodological tools, cost-benefit analysis, game theory, and empirical evaluation. Law and economics employs diverse analytical tools. Cost-benefit analysis compares social costs and benefits of legal rules to identify efficient outcomes. Game theory models strategic interactions among rational actors to predict behavior under different legal regimes. Empirical evaluation uses statistical methods to test hypotheses about laws' effects on behavior and outcomes. Real-life example, environmental regulations often undergo cost-benefit analysis to justify stringency. Game theory explains why parties may settle litigation rather than proceed to trial. Empirical studies evaluate the deterrent effect of tort liability on accident rates. Practical application, lawyers conduct cost-benefit analyses for regulatory comments, use game theory to design settlement strategies, and interpret empirical evidence in litigation. Students practice methodological applications. They learn to evaluate economic arguments critically. 1.3 Schools of Thought, Chicago, Behavioral, and Institutional Approaches. Different schools emphasize distinct aspects of law and economics. Chicago School emphasizes market efficiency, rational choice, and minimal regulation. Associated with Posner, Becker, and Coase. Behavioral law and economics incorporates psychological insights about bounded rationality, biases, and heuristics. Challenges pure rationality assumptions. Institutional economics focuses on how legal and social institutions shape economic behavior and development. Real-life example, the Chicago School's influence on antitrust law emphasized consumer welfare and efficiency, leading to more permissive merger review. Behavioral insights have informed consumer protection regulations addressing cognitive biases. Institutional analysis explains why similar laws produce different outcomes across jurisdictions. Practical application, lawyers draw on different schools depending on context and client objectives. Students practice analyzing legal issues through multiple economic lenses. They learn to synthesize theoretical perspectives. 2. Applications to substantive legal domains. 2.1 Property and Contract Law, Coase Theorem, Information Asymmetry, and Relational Contracts. Economic analysis illuminates foundational private law doctrines. Coase Theorem: if transaction costs are low and property rights are clear, parties will bargain to efficient outcomes regardless of initial entitlements. This informs debates on liability rules versus property rules. Information asymmetry: when one party has superior information, legal rules, disclosure duties, warranties, can reduce inefficiencies from adverse selection and moral hazard. Relational contracts: long-term relationships rely on informal enforcement mechanisms, law should supplement rather than displace these. Real-life example: in Boomer v. Atlantic Cement Company, 1970, the court denied an injunction for nuisance but awarded permanent damages, reflecting Coasean reasoning. If bargaining costs are high, liability rules may achieve efficient outcomes. Disclosure requirements in securities law address information asymmetry. Practical application: lawyers draft contracts that mitigate information problems, advise on property disputes using Coasean analysis, and design relational governance structures. Students practice applying economic concepts to private law scenarios. They learn to balance efficiency with fairness. 2.2 Tort law, deterrence, insurance, and enterprise liability. Tort law serves economic functions of deterrence and loss spreading. Deterrence: liability rules should induce optimal precaution by potential injurers and victims. Insurance: tort system interacts with insurance markets, no-fault schemes may reduce transaction costs. Enterprise liability: holding firms liable for employee torts internalizes accident costs and incentivizes safety investments. Real-life example: strict liability for ultra-hazardous activities reflects deterrence logic, actors engaging in risky activities should bear costs. Workers' compensation systems illustrate no-fault alternatives to tort litigation. Practical application: lawyers argue for liability standards that promote efficient deterrence, advise on insurance strategies, and litigate enterprise liability claims. Students practice economic analysis of tort doctrines. They learn to evaluate trade-offs between deterrence and compensation. 2.3 Criminal law, deterrence, incapacitation, and cost of enforcement. Economic analysis informs criminal law design and enforcement. Deterrence: sanctions should outweigh expected benefits of crime, considering detection probability. Incapacitation: imprisonment prevents recidivism but imposes social costs. Enforcement costs: optimal enforcement balances deterrence benefits against investigation and prosecution expenses. Real-life example: sentencing guidelines incorporate economic reasoning by calibrating penalties to offense severity and defendant characteristics. Plea bargaining reduces enforcement costs but raises fairness concerns. Practical application: lawyers advise on sentencing policy, represent defendants in plea negotiations, and litigate constitutional challenges to criminal statutes. Students practice economic analysis of criminal law. They learn to balance efficiency with justice. 2.4 Constitutional and administrative law, public choice, regulatory capture, and judicial review. Economic analysis extends to public law institutions. Public choice theory models political actors as self-interested, explaining legislative logrolling and regulatory capture. Regulatory capture: agencies may serve industry interests rather than public welfare, suggesting institutional design reforms. Judicial review: courts can correct market failures and political process defects, but face information and legitimacy constraints. Real-life example: campaign finance regulations address public choice concerns about money's influence on politics. Independent agency structures aim to reduce capture risks. Practical application: lawyers advocate for institutional reforms, litigate constitutional challenges, and advise agencies on rulemaking. Students practice economic analysis of public law. They learn to evaluate institutional design. 3. Policy analysis and reform, evaluating legal rules and designing interventions. 3.1 Evaluating legal rules, efficiency, distribution, and administrative feasibility. Law and economics provides frameworks for policy evaluation. Efficiency analysis identifies rules that maximize social wealth, considering direct and indirect effects. Distributional concerns, efficiency may conflict with equity, policy should address both. Administrative feasibility, rules must be implementable at reasonable cost. Real-life example, carbon pricing, tax or cap-and-trade, is economically efficient for reducing emissions, but distributional impacts, regressive effects, may require complementary policies like rebates. Administrative feasibility affects policy choice. Practical application, lawyers conduct policy analyses for legislative proposals, advise on regulatory design, and litigate to enforce or challenge rules. Students practice evaluating legal rules using economic criteria. They learn to integrate efficiency and equity considerations. 3.2 Designing legal interventions, nudges, default rules, and choice architecture. Behavioral economics informs policy design through subtle interventions. Nudges, altering choice architecture to guide behavior without restricting options, e.g., opt-out organ donation. Default rules, setting efficient defaults for contracts and regulations reduces decision costs. Choice architecture, structuring information and options to improve decision-making. Real-life example, retirement savings plans with automatic enrollment, opt-out, increase participation rates, illustrating nudge effectiveness. Default contract terms reduce negotiation costs. Practical application, lawyers design contracts and regulations incorporating behavioral insights, advise on compliance strategies, and advocate for evidence-based policy. Students practice designing interventions. They learn to apply behavioral economics to legal contexts. 3.3 Empirical legal studies, data, methods, and causal inference. Empirical methods test hypotheses about law's effects. Data sources, administrative records, surveys, and experiments provide evidence. Methods, regression analysis, natural experiments, and randomized controlled trials establish causal relationships. Causal inference, distinguishing correlation from causation requires careful research design. Real-life example, studies on right-to-carry laws use difference-in-differences methods to estimate effects on crime rates. Findings inform policy debates despite methodological controversies. Practical application, lawyers interpret empirical studies for litigation and policy advocacy, commission research to support positions, and challenge methodological flaws. Students practice empirical analysis. They learn to evaluate evidence critically. 4. Contemporary issues and professional preparation. 4.1 Technology and innovation, intellectual property, platform regulation, and AI governance. Economic analysis addresses legal challenges posed by technological change. Intellectual property, balancing innovation incentives with access and follow-on innovation. Platform regulation, network effects, data control, and competition policy for digital markets. AI governance, liability for algorithmic decisions, data governance, and innovation incentives. Real-life example, patent law's obviousness standard reflects economic reasoning about innovation incentives. Antitrust enforcement against tech platforms considers network effects and data advantages. Practical application, lawyers advise on IP strategy, represent clients in platform regulation matters, and litigate technology disputes. Students practice economic analysis of tech law issues. They learn to balance innovation with competition and consumer protection. 4.2 Globalization and development, trade, investment, and institutional quality. Law and economics informs international policy and development strategies. Trade policy, comparative advantage, terms of trade, and distributional effects of globalization. Investment protection, balancing investor rights with host state regulatory autonomy. Institutional quality, property rights, contract enforcement, and rule of law as foundations for development. Real-life example, investor-state dispute settlement, ISDS, mechanisms protect foreign investment but raise concerns about regulatory chill. Economic analysis helps design balanced treaties. Practical application, lawyers advise on trade and investment agreements, represent parties in ISDS proceedings, and advocate for development-oriented policies. Students practice analyzing global economic issues. They learn to navigate cross-border complexities. 4.3 Learning Outcomes and Competency Benchmarks. By completing law and economics, students should be able to apply economic concepts to legal analysis and advocacy. Evaluate legal rules using efficiency, distributional, and feasibility criteria. Design policy interventions informed by behavioral and empirical insights. Address contemporary challenges, technology, globalization. Practical application, these outcomes prepare students for policy advocacy, regulatory practice, and interdisciplinary legal work. Mastery ensures effective engagement with economic dimensions of law. 4.4 Assessment methods, policy memos, empirical critiques, and reform proposals. Assessments include policy memos, analyze legal rules using economic frameworks. Empirical critiques, evaluate studies supporting or challenging legal doctrines. Reform proposals, design evidence-based legal interventions. Real-life example, a final project might involve proposing a regulatory reform for platform markets, combining economic analysis, empirical evidence, and legal drafting. This mirrors real-world policy work. Practical application, students should practice integrated economic legal thinking and communication. 4.5 Transition to capstone and beyond, law and economics as foundation for analytical practice. Law and economics prepares students for the capstone project and careers requiring rigorous policy analysis. Capstone project integrates economic analysis in a substantial work product. Professional entry equips students to handle complex policy and regulatory matters. Analytical edge, economic reasoning enhances legal strategy and advocacy. Practical application, students should view law and economics as a powerful analytical toolkit. Mastery ensures versatile and impactful legal practice. Slide 11. Year 4, Semester 2, Capstone and Specialization. Course, Law.450, Capstone Project. Foundations of the Capstone Project, Integration, Originality, and Professional Preparation. 1.1 Purpose and Scope, Synthesizing Legal Knowledge for Professional Practice. The Capstone Project represents the culmination of legal education, requiring students to integrate knowledge, skills, and values acquired throughout the program. Unlike traditional coursework, the capstone emphasizes original research, practical application, and professional presentation. Integration, students synthesize doctrinal knowledge, analytical skills, and ethical commitments across multiple legal domains. Originality, projects must contribute novel insights, whether through empirical research, doctrinal analysis, policy proposals, or creative applications. Professional preparation, capstones simulate real-world legal work, preparing students for practice, policy, or academic careers. Real-life example, a capstone on algorithmic bias in criminal sentencing might integrate constitutional law, evidence, civil rights, and data science, producing a policy brief for legislators or a litigation strategy for advocacy organizations. This illustrates the integrative and practical nature of capstone work. Practical application, students select topics aligned with career interests, develop research questions, and design methodologies. They consult with faculty advisors to refine scope and ensure feasibility. They learn to manage long-term projects with professional standards. 1.2 Project types, research papers, policy proposals, litigation strategies, and creative applications. Capstone projects take diverse forms, reflecting varied career paths and interests. Research papers, traditional scholarly articles contributing to legal doctrine or theory. Policy proposals, draft legislation, regulatory comments, or advocacy strategies addressing contemporary issues. Litigation strategies, comprehensive plans for complex cases, including factual investigation, legal research, and procedural tactics. Creative applications, interactive tools, educational materials, or community resources that apply legal knowledge to practical problems. Real-life example, a policy proposal capstone might draft model legislation for data privacy, combining comparative law analysis, stakeholder consultation, and statutory drafting. A litigation strategy capstone might develop a comprehensive plan for a class action on environmental justice, integrating substantive law, procedure, and advocacy tactics. Practical application, students select project types based on career goals and advisor guidance. They develop proposals outlining objectives, methods, and deliverables. They learn to tailor projects to professional audiences. 1.3 Methodological rigor, research design, source evaluation, and ethical compliance. Capstone projects require methodological rigor appropriate to their form and discipline. Research design, clear questions, appropriate methods, doctrinal, empirical, comparative, and feasible timelines. Source evaluation, critical assessment of primary and secondary sources, including case law, statutes, scholarly literature, and empirical data. Ethical compliance, adherence to academic integrity, human subjects protections, for empirical research, and professional ethics. Real-life example, an empirical capstone on sentencing disparities might use regression analysis of court data, requiring IRB approval, data cleaning, and statistical validation. This illustrates the methodological demands of rigorous legal research. Practical application, students develop research protocols, consult with methodology experts, and document procedures. They learn to defend methodological choices and address limitations. 2. Project development, topic selection, research, and analysis. 2.1 Topic selection, identifying gaps, aligning interests, and ensuring feasibility. Successful capstones begin with thoughtful topic selection. Identifying gaps, reviewing literature to find underexplored issues or emerging challenges. Aligning interests, choosing topics that match career aspirations, personal passions, and advisor expertise. Ensuring feasibility, assessing resource availability, time constraints, and access to data or stakeholders. Real-life example, a student interested in technology law might identify a gap in regulation of deepfake technology, align with a faculty advisor specializing in media law, and ensure feasibility by focusing on a specific jurisdiction or use case. Practical application, students conduct literature reviews, consult with advisors, and draft project proposals. They learn to balance ambition with practicality. 2.2 Research process, primary and secondary sources, interdisciplinary approaches, and iterative refinement. Capstone research requires comprehensive and critical engagement with sources. Primary sources, case law, statutes, regulations, treaties, and original data. Secondary sources, scholarly articles, treatises, policy reports, and expert commentary. Interdisciplinary approaches, drawing on economics, political science, sociology, or technology to enrich legal analysis. Iterative refinement, research questions and methods evolve based on findings and feedback. Real-life example, a capstone on climate litigation might analyze judicial decisions, primary, review scholarly debates on standing and remedies, secondary, incorporate economic analysis of damages, and refine focus based on emerging case law. Practical application, students develop research strategies, manage sources systematically, and adapt to new insights. They learn to synthesize diverse materials into coherent arguments. 2.3 Analytical frameworks, doctrinal, policy, empirical, and critical approaches. Capstone analysis employs frameworks suited to project goals. Doctrinal analysis, interpreting and synthesizing legal rules and principles. Policy analysis, evaluating rules based on goals, impacts, and feasibility. Empirical analysis, testing hypotheses using data and statistical methods. Critical approaches, examining power, inequality, and ideology in legal doctrines and institutions. Real-life example, a capstone on criminal justice reform might combine doctrinal analysis of sentencing statutes, policy evaluation of reform proposals, empirical assessment of recidivism impacts, and critical examination of racial disparities. Practical application: students select and apply analytical frameworks, justify methodological choices, and address counterarguments. They learn to produce nuanced, evidence-based analysis. 3. Project execution, writing, presentation, and professional standards. 3.1 Writing and drafting, structure, clarity, and persuasion. Capstone writing must meet professional standards of clarity, organization, and persuasion. Structure, logical flow from introduction to conclusion, with clear headings and transitions. Clarity, precise language, defined terms, and accessible explanations of complex concepts. Persuasion, evidence-based arguments, anticipation of counterarguments, and compelling conclusions. Real-life example: a policy proposal capstone might use executive summaries, issue statements, and actionable recommendations to persuade policymakers. A research paper might follow law review conventions with footnotes and extensive citations. Practical application: students draft iteratively, seek feedback, and revise for clarity and impact. They learn to tailor writing to target audiences. 3.2 Presentation and defense, oral advocacy, visual aids, and Q&A preparedness. Capstone presentations simulate professional contexts like client meetings, legislative testimony, or academic conferences. Oral advocacy, clear, concise, and engaging delivery of key arguments. Visual aids, slides, charts, or demonstrations that enhance understanding without distracting. Q&A preparedness, anticipating questions, acknowledging limitations, and responding thoughtfully. Real-life example: a capstone defense might involve presenting findings to a panel of faculty and practitioners, fielding questions on methodology, implications, and limitations. This mirrors real-world professional presentations. Practical application: students practice presentations, refine visual materials, and prepare for Q&A. They learn to communicate complex ideas effectively under pressure. 3.3 Professional standards, citation, ethics, and collaboration. Capstone work must adhere to professional norms. Citation, consistent, accurate citation following Blue Book or institutional guidelines. Ethics, academic integrity, no plagiarism, human subjects protections, and disclosure of conflicts. Collaboration, if applicable, clear attribution of contributions and effective teamwork. Real-life example: a collaborative capstone on community legal needs might involve interviews with stakeholders, requiring informed consent, confidentiality protections, and transparent reporting of methods. Practical application: students document sources meticulously, obtain necessary approvals, and acknowledge contributions. They learn to uphold professional ethics in research and writing. 4. Contemporary issues and professional preparation. 4.1 Technology and capstone projects, digital tools, data analysis, and online presentation. Technology enhances capstone development and dissemination. Digital tools, reference managers, data analysis software, and collaborative platforms streamline research and writing. Data analysis, statistical packages, visualization tools, and machine learning enable empirical projects. Online presentation, websites, videos, or interactive formats expand reach and impact. Real-life example: a capstone on legal tech might develop a prototype tool for document automation, combining legal analysis with software development and user testing. Practical application: students leverage technology appropriately, document methods, and ensure accessibility. They learn to integrate technical and legal skills. 4.2 Global and interdisciplinary perspectives, comparative law, cross-border issues, and collaborative research. Capstones increasingly address global challenges and interdisciplinary questions. Comparative law, analyzing legal approaches across jurisdictions to inform reform. Cross-border issues, addressing transnational problems like climate change, migration, or digital governance. Collaborative research, partnering with scholars, practitioners, or communities for richer insights. Real-life example, a capstone on refugee protection might compare asylum procedures in multiple countries, interview stakeholders, and propose harmonized standards. Practical application, students conduct comparative research, navigate cross-border complexities, and manage collaborative dynamics. They learn to work across disciplines and cultures. 4.3 Learning Outcomes and Competency Benchmarks. By completing the capstone project, students should be able to integrate legal knowledge across domains for original analysis, design and execute rigorous research projects, communicate findings effectively to professional audiences, uphold ethical and professional standards in legal work. Practical application. These outcomes prepare students for immediate contribution to legal practice, policy, or scholarship. Mastery ensures readiness for professional challenges. 4.4 Assessment Methods, Proposal Review, Draft Feedback, and Final Defense. Assessments include Proposal Review, evaluating topic selection, research design, and feasibility. Draft Feedback, providing iterative guidance on analysis, writing, and methodology. Final Defense, assessing presentation, Q&A, and overall project quality. Real-life example, a capstone defense panel might include faculty, practitioners, and community stakeholders, providing diverse perspectives on project impact and professionalism. Practical application, students should practice receiving and incorporating feedback, refining work based on critique. 4.5 Transition to Professional Practice, Capstone as Launchpad for Career Impact. The capstone project prepares students for entry into the legal profession. Professional portfolio, capstones demonstrate research, writing, and analytical skills to employers. Network building, advisor relationships and presentation audiences create professional connections. Lifelong learning, capstone experience instills habits of rigorous inquiry and continuous improvement. Practical application, students should view the capstone as a foundation for career development. Mastery ensures confident entry into professional practice. Begin your legal journey, take the first step. Triune Biblical University Global Extension USA, concluding enrollment information. To our distinguished current and returning students across the globe, we extend our formal academic welcome and professional congratulations on your progression through the Bachelor of Law curriculum at Triune Biblical University Global Extension USA. This concluding module marks the transition from academic study to professional practice. The comprehensive legal education you have undertaken, spanning foundational doctrine, procedural competence, ethical formation, and global perspective, positions you for meaningful contribution to the legal profession and the advancement of justice worldwide. We acknowledge with gratitude the visionary leadership of President/Chancellor Reverend Professor Adelik Daniel Durojiye, Diplomate Erudite Professor, whose scholarly excellence and administrative stewardship have established this institution as a beacon of rigorous, accessible, and ethically grounded legal education across global communities. Take the first step. Ready to shape your legal career? Phone, +164 6409 4299. Email, info@tbuglobalextensa.com. Website, www.tbuglobalextensionusa.com. Address, 131, Baybright Drive East, 11967, 4136 Shirley, New York, USA. Enroll today. Be diligent to present yourself approved to God as a workman who does not need to be ashamed, rightly dividing the word of truth. 2 Timothy 2 verse 15. Interpreted academically, this motto emphasizes the hermeneutical precision, methodological rigor, and ethical commitment that define exemplary legal practice, the diligent pursuit of truth through precise textual analysis, rigorous reasoning, and unwavering professional integrity. May your legal journey be marked by intellectual excellence, ethical commitment, and enduring contribution to justice, equity, and the rule of law.